afternoon.
Your Honor, the evidence found in the storage locker by Detective Barron should not be suppressed in today's case. There was no violation of the Fourth Amendment in this situation. The defense's claim today that Detective Barron's search was unconstitutional. It was not. Detective Barron, in fact, received consent twice, Your Honor. First, when Ms. Shem told him that he could take a look around, which of course includes the storage unit included within the apartment complex and within his lease. And second, when Ms. Gibbons showed him the storage locker as a cohabitant. On my first point, Your Honor, Detective Barron believed in good faith that Ms. Shem's consent encompassed the storage unit included within the apartment complex. Although the locker is not physically within the apartment, it is on the property of the apartment complex and property of Ms. Shem. Although the locker was not...
You just said, you sounded like you were going to launch into a good faith argument.
Yes.
And then you went back and started talking about the scope of consent. They're two different things.
Because I was, and I still have it written in, but I was going to skip over it today because of what we discussed yesterday. I was going to talk about Florida v. Jimeno here, but my argument was that it was, I was saying that it was held objectively reasonable for the officer to search inside items within the vicinity of the car, but it's more of a defense case.
Okay, so the way you frame it up, two things, just like we did with Julianne. Two things. The first point that you need to make is that first, the officer received sufficient consent or acted within the bounds of the consent given by Evan Shem. Number two is that even if the court does not feel that the officer acted within the scope of consent given by Evan Shem, that the officer acted in good faith based on the facts that he knew or she knew. Okay? And once you frame it with those two things, you then go back to point number one and you start talking about scope of consent. Okay?
So I do want to talk about Ms. Gibbons first before I go into the fact that Ms. Shem gave the officer permission, or that it, or wait, no.
You're just summarizing your legal arguments.
Okay.
Okay? Scope of consent,
right.
Good faith.
Right.
Scope of consent, good faith. Then go to scope of consent first.
Okay.
Okay?
Okay.
Does that make sense?
Yes.
We'll work on that, but just do that.
Try it the best you can today, Alexis. That's good.
Okay. So I'll
Just pick it
move
up
on.
where we need to.
Okay. The storage locker is owned by Evan Shem in the same way, say, a bathroom in the apartment is, as in U.S. v. Pena. In this situation, although the bathroom was closer to the vicinity of the main and central area of the apartment, and the storage unit is adjacent to the apartment, Ms. Shem owns both under his rent and stores his possessions in both locations. Additionally, Ms. Gibbons did and could give consent to the search of the storage unit. Matlock and U.S. v. Davis both state that cohabitants may consent to the search of common areas. Ms. Gibbons had stored her bike in the apartment storage locker and thus had frequent access to the area. The facts of today's case are distinguishable from Davis because Ms. Gibbons only consented to the search of common areas, whereas in Davis, the roommate consented to a search of areas that were not altogether common. The facts of today's case are distinguishable from Davis, yet still, no.
Yeah, that's okay.
Furthermore, it was held objectively reasonable for Detective Barron to believe Ms. Gibbons could and did consent to this search because Detective Barron reasonably believed that Ms. Gibbons was a co-occupant of the apartment. As held in Matlock, it is lawful for a co-occupant to consent to the search of common areas. Detective Barron saw Miss Gibbons in the parking space the day before. She saw Miss Gibbons taking out the trash for the apartment the day before. And Miss Gibbons had access to the key for the storage unit, told Detective Barron how to access the key, and essentially informed him that he could access the key.
And Gibbons denied consent to the officer the day before. Don't forget that fact. The officer went and said, "Hey, can I look in the apartment?" And Charlie Gibbons said, "No, you can't."
Right, I
And
think
that
the
fact-
only reason I didn't include that was because of the negativity.
No, who cares?
But- okay.
No.
Okay,
That's
so,
that's a really important point. You know why that's an important point? Because you, as the prosecution,
just have to prove.
can argue, look, this officer did everything right. He went back, if he was trying to get around the Fourth Amendment and get around the consent requirement, he wouldn't have gone back and asked the same co-tenant who refused consent the day before, right? He wouldn't have gone to that person. He obviously went to the person he thought lived there, because the guy
Right.
said, "Charlie, you can't go into that apartment." So he went back to the same person who denied the day before. Sorry.
Remember, Detective Barron will always
Yeah.
be female, Charlie Gibbons will always be female. The only one you have to worry about is Evan Shem.
Right. So this officer did everything. Right, this officer did do everything in her power to make sure that it was a lawful search. The day prior, she even asked Charlie Gibbons if she could search the apartment, while Charlie Gibbons declined then, the next day, she asked Charlie Gibbons if she could search the storage unit and if it belonged to the same apartment complex, the same apartment, where Gibbons informed her that she could find the key within the apartment and how to obtain it.
I think one way to hammer home the point that you're going back and forth on is something along the lines of when Detective Barron asked for permission to search the apartment, Charlie Gibbons didn't say, "Oh, I'm not sure this isn't my apartment. I don't know. I don't live here. I need to ask Evan." Charlie Gibbons said no. So of course it was perfectly reasonable for Detective Barron, in good faith, to assume that Charlie had the right to say it, because it was in fact Charlie.
Yeah, say it just like that.
Exactly.
Say it just like that.
Beautiful.
Now, there is a danger, by the way, in stressing too much, for the prosecution to stress too much, that Charlie Gibbons was like, "No, don't come in this apartment."
Right.
Because that.
It's gonna come out anyway during the trial.
What?
It'll probably come out during the trial anyhow.
Right, right. Yeah.
It's not his apartment.
Yeah.
She merely said no. Or she said, yeah, she said no.
Wow, and Alexis, you're doing great.
Thank you. Okay, so I'll
Okay, go ahead.
go back to that argument later, or anyway. So as in Fernandez, where police obtained consent to search an apartment from someone they reasonably believed to be a co-occupant, today's Detective Barron reasonably believed that Ms. Gibbons was a co-tenant. Let's talk about Ms. Gail Fisher for a moment. In Illinois v. Rodriguez, Ms. Fisher went to police and told them that Ms. Gail Fisher informed police that she lived in the apartment and had belongings in the apartment. This is all that they needed to go on. When police arrested the defendant and the case went to the Supreme Court, the U.S. Supreme Court ruled that while Ms. Gail Fisher merely claimed to live in this location and had belongings in the apartment, the police could have arrested the defendant on that alone. Then,
It has nothing to do with arrest. No. What you're trying to say is very simply that all Gail Fisher said in that case was, "There are drugs in our apartment."
right,
The officers only had that information, that she was at the front door and she said, "This is our apartment." And they reasonably believed that Gail Fisher was a co-tenant, co-occupant, and they acted based on that reasonable belief. Here in our case, Officer Reese Barron acted on a lot more facts than just that.
Good.
into, and then I was, in my original, I was going to go into talking about Jenkins here, but it's not, correct me if I'm wrong, but it's not necessary for today's case. I don't, that's what we talked about,
What does, remind me what Jenkins
yesterday.
says? Can you,
It's that, it's for the
Ariel?
brother and sister.
can you turn that page over that you have of mine?
It's where the brother
yeah,
and sister.
for sure.
Okay.
We
No.
talked about prosecution.
I don't need it
has,
anymore, I already copied it.
1, 2, 3, 5. They have 6 cases, and to me, Jenkins is the weakest case. So and when we did the scrimmages with the elite teams, nobody used the Jenkins case. There's a lot of distinguishing facts that make it, easy for the defense to, shoot down that case. So that's why I wouldn't even use it, but see what Sean thinks.
What do you guys? I'm not good at this. Let me try.
Well, basically you have to analogize this to the key, right?
Right. Well, I've been, actually, in my argument, I compared it to when Shem gave Gibbons access to the locker to store her bicycle. Because that was,
Yeah, but and Jenkins is literally a briefcase with a gun in it, and it's
Right.
unlocked. And Diane says, "Here, take a look at my brother's unlocked briefcase."
unlocked.
And they go, "Oh, okay." Boom, and there's a murder weapon in there. Thank you very much. And they go, "Yeah, of course she had. It was objectively reasonable to assume that she had joint and exclusive access over the case because she had it in her possession."
Right.
On the other hand, here we have Charlie Gibbons pointing out where the key is inside of the house. Charlie Gibbons is not in possession of the key. He doesn't pull it from his pocket, right?
Okay.
So I wouldn't use this case.
Okay.
I forget these. I read these cases and then I forget them. Okay.
And then is that the same with Jimeno, where it just doesn't work for my argument?
I thought you could use, I made some notes last night, and we didn't get a chance to read these, but I didn't have a problem with using Jimeno, but when you talked about being in the vicinity, that's misleading, and.
Yeah, she said adjacent, right?
Well,
You mean the storage locker?
The storage unit in the witness statements and the facts, it says adjacent. I said vicinity in my argument. Well, I actually haven't said
Oh.
my argument, but
All right.
well, yeah, I just made a note to myself that there's no discussion of vicinity in the case that you cited. You're stretching the case holding, and it's misleading and a big no-no, so.
for the actual Jimeno case.
But
see.
I did, I'll show you afterwards, there is a way to
Okay.
use the case, but without going down the path.
Oh, okay. Thank
We
you.
have a suggestion when you're done, not just for you individually, but just keep going and
Okay.
we'll help you out in a few minutes in another way too.
Alright,
Oh,
go.
this is actually mine. Sorry, I don't know why I keep saying, actually I do know why.
Okay, go ahead. Just finish your argument, so, and then I'll.
Your Honor, the defense has requested today that we not even consider that Evan Shem had a list of potential customers for this painting. In conclusion, based on the facts of this case and the relevant case law that we have discussed today, it is clear that this search was perfectly reasonable and perfectly constitutional. Ms. Gibbons could give consent to the storage unit and did. Of course, by then, it did not even matter because Evan Shem already had. Thank you, Your Honor.
Wanna go?
Okay.
No, no.
Rebuttal, Your Honor?